All right, welcome back. If you just joined us, it's News Up. Why do I always want to say today's business? Well, it's News Up. We're doing business on News Up today. And then, like we did intimate, our focus of conversation will be around the series of conflicting court orders and then the invitation by the Chief Justice of the Federation, who seems to have come to the rescue. We did read in one of the headlines this morning that next week, 3 of those judges would have to face the panel at the NJC. You see, Messi, we talked about this at the beginning of the show, and it's important we need to keep hammering this. The place of judiciary in achieving true democracy, in the sustainability of our democratic process. It's important that judiciary should wake up to its responsibility. We're tired of having cases of judiciary deciding who becomes a governor of a state. We're tired of having judiciary decide who becomes the president of a country. We're tired of having judiciary determine who becomes the local government chairman or who becomes, these are responsibilities for the electorate and not judiciary. And then having issues like ex parte orders, conflicting judgments from courts of equal jurisprudence, like they say in the law terms of equal jurisprudence, it begins to bother us as to how true to their calling is the judiciary. I could recall, I think. I stand corrected, but I think I did hear the president in the early hours of his administration when he made mention of the fact that judiciary is one of the problem of the country. Judiciary is part of the concerns of democracy in Nigeria. So I think as we stand, the judiciary will be facing what I would call a litmus test. A litmus test, we have ex parte orders flying here and there, court judgments, and now we also have the case of the VAT still coming to the fore. I believe that this might end up at the Supreme Court going forward, because I'm sure the federal government would, or rather the FRS would, appeal whatever judgment is being held by the High Court judge in Rivers State. So many concerns around judiciary and the need for judiciary to be able to sustain this democracy, these concerns around fairness, these concerns around justice and fairness is extremely very key.
Absolutely, I totally agree with you. The third arm of the government is very important, in every setting, especially like a democracy like ours, And you asked the question, you made a statement about the court being the one now who determines who becomes the president, who becomes the governor.
Yes.
And Imo State has already shown us that, and how people are even dismissed at the outcome of the court's judgment. Yes. And while I was making my research, I asked myself, is this a foreshadow? Is this a sign, like they would say in the biblical language, is this a sign of things to come? In the sense that the election results comes out. See what happened in Anambra State as well. Even in party, this is a matter of in party. We've even gone outside the party. Yeah. It's not even inter-party this time around. Yeah. Where I am aggrieved. I feel like the election result does not reflect the will of the people. Yeah. And I go to court and I say, I'm going to fight this thing, oh God, this is not the real result. And the court goes, we go round and round and round and round the circle, and they bring the result and they say, my opponent won. And the next thing I'm like, no, this is not actually the right thing. I'll move elsewhere. Now, if the will of the people is reflected in the fact that my opponent won, and I'm claiming that I won, and the court ruled in my favor, something would have gone wrong there. You said President Buhari was saying at the beginning of his rule that judiciary, is one of exactly. Who caused the problem in the judiciary? I was listening to a video of one of the ex-NBA presidents, speaking about corruption matters in the judiciary. And he said the people who actually give the bribe is as guilty, or they are as guilty as the people who actually receive the bribe. The way the people who receive the bribe should be punished is the way the people who receive the bribe should be punished. Who are the ones who introduce this corruption to the people? It is politics. And the politics is eating into everything. And now the judiciary is, you see, this is a rot that has been happening since, that is just showing its ugly side now. And people are frowning against it. There are good people who are doing a good work in the system, and they are hell-bent on ensuring that they give justice where it is due and defend the weak and the poor. But the bad eggs seem to be the one who is painting the entire, sector in a bad light. And this is actually very, very bad. And I'm scared, I can tell you that for real, of what 2023 holds. Because this fight is just, I don't know. We just saw the governorship, what's it called, tussle in Anambra, inter-party governorship tussle in Anambra. What is going to happen in other states?
Okay, we'll just keep our fingers crossed and see how all of this play out in the future. Yes, I didn't say it, but let me just say this, that we are hoping to hook up to a few of our experts on this matter to do justice to this conversation. We will be having Anthony Oseme, he's a legal practitioner. We'll also be looking at having Henry Ikine, also a legal practitioner from Port Harcourt. But then I've just been told that we have on the phone, we have Monday Ubani. Monday Ubani was the former deputy president of NBA. Yes, so good to have you join us via phone, Mr. Ubani.
Yeah, thank you, David.
Yes, good to have you join us. Yes, we're looking at judiciary in the front burner at the moment. Key conversations around recent happenings within the judiciary, conflicting court orders. We saw what happened during the PDP chairmanship tussle, where a court did rule in Port Harcourt. Then there was a counter judgment of the same court of equal jurisprudence in Kebbi State, and the tussle goes on and on. We see what's happening in Anambra governorship, governorship tussle as we speak. Barrister Ubani, why, in your own perspective, why do we have same courts in the same country with equal jurisprudence giving conflicting orders over a particular case? Why on earth should we have that happen?
Yeah, thank you. The issue has been addressed both by the bar and the bench. If you remember that the CJN, first of all, invited all the chief judges of the various states where those strange orders were emanating from, and had a discussion with them. And then also promised that those erring judges will certainly be punished. I think what he did is, I think they have actually issued them query to give an explanation. You cannot convict any person without hearing from that individual. So they want to hear from those judges what could have led them to be given these conflicting and the contradictory orders, especially coming from courts of coordinate jurisdiction. That is clearly strange. We know it principally that a court of the same jurisdiction cannot, or coordinate jurisdiction cannot sit on appeal over a case that partly emanates from the same court of coordinate jurisdiction. It can only be revised on appeal to appellate courts. But this issue of don't go or be restrained, or no, go back, or I reinforce you, with the same court of coordinate jurisdiction, it's a bit strange. And so they need to explain what actually happened. Is it the lawyers that may have misled them, or is it the politician that must have misled the lawyers? So getting to know what led to all these bizarre orders, is what we are in now. The bar is investigating. The bench is also investigating all this. So we are all concerned.
I mean, these are real concerns that we need to take a look at and solve as soon as possible. But before we go on into more technical aspect of this particular issue, whenever a judgment is given by any of the courts, we hear ex parte motion, ex parte order, ex parte this, ex parte that. And we have a lot of laymen listening to us. We have people in engineering, people in, who are not lawyers. Could you please break it down? What is this issue of ex parte order? Could you break it down so everybody understands it?
Ex parte order is an order that is gotten from a court, on the evidence or fact of only one party. It is actually used in extreme urgent cases where there is evidence that if the court does not intervene, the rest, that is the subject matter, will be destroyed permanently, and there will be no remedy to the aggrieved person, either in damages or in compensation. When there is no likelihood of being compensated in damages, the best thing that the court will do is to ensure that that rest, the subject matter, is not destroyed by granting what you call interim injunction. And then give a notice that to the other party that they should come and argue motion on notice. Yeah, there will be a motion for which the other party now will now put forth his own facts, either contradicting or affirming what the aggrieved party has placed before the court. But if the court is of the view that if interim injunction is not granted, the subject matter will be destroyed permanently, the court can make an interim order immediately. And it's usually used in matters of extreme urgency. It's not something you just begin to dish, out, at whims and caprices. And that's why some of the judges of the various courts of jurisdiction have actually warned judges to exercise some level of caution and some level of restraint in granting ex parte injunction. Because we can use ex parte to destroy many things in the country, which is actually what is going on now, where you are using it now to remove a substantive chairperson who has already been arrested and identified as
We're having challenge with hearing properly.
Yes, I can feel that there is an issue, technical issue.
Okay, but then it's a lot better now. You can continue, Sabani. You can continue. We can hear you now.
Yeah, sorry. Yeah. So as I said earlier, a situation where you use a parte order to now remove a substantive chair is a bit strange. More so, you don't grant an injunction for an act that has already been completed. Are you following me? You don't restrain a completed act. It's a fundamental principle in the issue of equitable remedies. You don't grant an injunction for an act that has been completed. The chairman you are asking you are restraining is occupying the position for many years now, and then a few months to his expiration, you are now saying he should be restrained. Restrained from what? He's occupying that position already, so you can't restrain him. So it sounds a bit strange, that you say you are restraining somebody who has already been elected and has been in position of authority for how many years, and all of a sudden you just now bring an order, trying to now say that he should not parade himself as the chairman of the political party. More so, you did this without hearing his own side of the story. So it's clearly a bit strange, and it's something that may have been influenced by political consideration, and that's why the bar and bench are trying to look into it, so that our politicians do not destroy our judicial system and, by extension, the Nigerian system.
Yes, Barrister Bani, very well said. So I'm trying to make an excuse here for the judge that did give the counter ruling to the initial one. Just maybe we could say he was not aware that there had been an initial ruling on that matter. Just maybe. So how do we begin to avert a recurrence of issues like this? How do we begin to ensure that when there's a ruling on a case, somehow it is made public, and every other court, every other judge is made aware that this case, there's a ruling on this case, because the judges could feign ignorance of the fact that there was a ruling on that particular case.
In the case under consideration, I'm talking about secondary case, the court in Kebbi made reference to the court decision in Rivers. So it's not true that they were not aware. What the court in Kebbi was saying that he should go back to office, meaning that there has been a restraining order. So he's now like sitting on appeal over the decision of the River State and asking the chairman to go and resume, if I granted him leave, to go back to his office and resume his duties. So it cannot be excused on the issue of ignorance. Then the one in Cross River, now say, I am asking you not to go back. based upon the decision that was reached in Rivers. So it's like a reinforcing order. So all the judges, all the three judges, cannot be said to be aware of what transpired in each of the jurisdictions. So yeah, I don't want to make an excuse for them. But on a serious note, too, on the issue of information, that's why we're saying technology should be deployed in running our administration of justice in the country, so that any decision reached in any jurisdiction can be probably put out there, so that judges will not be making contradictory orders. Remember that there has been this resurgence of conflicting orders, even by appellate courts. When a court, a particular division gives a decision on the same facts, another court will now take a different position. There has been many cases like that has been suffering from this issue of conflicting orders. Most times, the state of the law is not yet settled until maybe it goes to Supreme Court. There are so many subject matters today, as I speak to you, that we have contradictory decisions by a court of appeal from different appellate jurisdictions. So we should deploy technology in order to ensure that all the courts in the land will be aware of decisions, so that they don't keep on giving contradictory orders, so that there won't be this issue of conflict, unsettled state of the law most of the times, because precedence is key, and we must settle the law. Yes. If law is settled, this issue of the instability, of conflicting decisions, put lawyers into clearly at risk, when they are carrying out the work of advocacy in court, and you're not too sure which one to side, because there has been conflict in decisions, especially from the appellate court. So I agree with you that we should deploy more technology in order to solve that problem. But on this particular matter, subject matter under discussion, the judges were all aware of the various decisions, so they cannot blame it.
But Barrister Obani, I'm also thinking, just maybe, the technology could be a long-term approach, but in the short-term approach, maybe a case of having the lawyers swear to an oath before they file in this case could also be a way of ensuring that they are not trying to oversmart or counter an initial judgment from another court. Maybe that could also work.
We are aware that one of the ethics of the profession is that a lawyer should not withhold information from a judge, even if that particular judgment is against you. You have to cite that judgment also to the court, and try to distinguish that decision from their own present case. So withholding of information or any adverse decision against you while engaged in advocacy is clearly unethical. So lawyers are really advised, to make available all cases, including the one in favor and the one against. That is one of the training and one of the ethics of the profession. So any lawyer that withholds information that is adverse to his position is actually committing an ethical wrong. Now, issue of making information available is also important. That's why for this time around, Mr. Olumidapata, the president of the bar, is also expressing some level of worry with these contradictory and conflicting orders, and that lawyers and very senior lawyers that are involved is, of course, of a great concern. And that's why the information is out there is that we should investigate and probably lay a solid standard that our colleagues should not engage in this, in forum shopping. They should not. And they should observe the best, international and best, what we call industrial practice, for the sake of the profession and for the sake of our polity. And for the sake of our persons, because integrity is key. One of the things lawyers are known for is the issue of integrity and honesty and competence. And then they are natural leaders anywhere they find themselves. So lawyers should not engage in anything that brings either the profession or their personality, to disrepute. These are issues we must begin to emphasize and ensure that our colleagues observe, failing which disciplinary measures will actually be meted out. I'm on my way to the court, so I don't know whether I can stop at this point. I'm sorry.
When matters like this happen and it is beyond what, you can handle in Nigeria or in Lagos, most of us will say, now, wow, you get CB. But thank you so much, Monday Ubani, a legal practitioner who actually joined us via the telephone to give, his own perspective on this issue. Thank you so much for joining us, sir. All right. We have some of our guests who are will be making contribution to this particular subject matter that is really, buzzing our heads here and there. We have from Delta States, Anthony Oseme. He's a legal practitioner. He'll be joining us via Zoom. And our Port Harcourt studio, Henry Ekine, also a legal practitioner. Who else would do justice to this matter than people who are actually in the profession? Gentlemen, thank you so much for joining us on today's edition of NewsHub.
Thank you for having me.
Absolutely.
Thank you for having me.
Let's start with our Port Harcourt guest, the one in the studio. Henry, I mean, let's start with what you make of this national embarrassment. I mean, we heard Barrister Monday Ubani speak earlier on. What do you make of what is happening so far? I mean, isn't it reactive? Why do we have to wait? Why does the judiciary system, those in the profession, have to wait until this time before making a move?
It's unfortunate, it's embarrassing, it is unacceptable, but it is not that the judiciary has been waiting or it's just about the first time that these reactions have come from the judiciary. No, it's always been that the superior courts, and of course including the NJC, have always been admonishing courts and judges, including lawyers, to avoid the scenario we have found ourselves that is now seriously embarrassing. That is, there have been condemnations of making conflicting orders and judgments over time. There have been series of condemnations of indiscriminate issuance of ex parte orders. It's not new, it's not now. So rather should see it the other way, that probably lawyers and some of our very distinguished judges departing from that admonition. So it's not like the judiciary is just responding, being reactive to it now and rather late, or the NJC being indolent about this kind of experience. It's been all over. Even in decisions of courts, it's been that judges should be very circumspect. It's become a household expression in applying or making ex parte orders in before ex parte applications before them. So I think that it's rather perhaps becoming too notorious this time. And again, with the infiltration of the political parties and politicians. So what I rather would subscribe is the courts and the NJC, which is the disciplinary institution of government on all judicial officers and of course in the judiciary, to be more assertive and be more emphatic in ensuring that erring lawyers and judges are reprimanded and of course disciplined accordingly. That I think is what is needed here. And then also to look critically on how to avoid rather than focus on punishment when these things come up. And I agree with Ubani. I had spoken about that sometime too. That I think that because one of the reasons it's been known that may one of the factors that may cause conflicting orders or decisions of court could be giving orders by that is by ignorance, and the ignorance could also be ignorance of the existence of a decision in that direction on the same subject matter or facts that are very similar or the same. And how would you hold a judge responsible in a very vast country as ours if technology is not deployed here, and then someone makes a judgment in as far as a very remote jurisdiction far away from the other, and then you expect, and sometimes in 1 or 2 days, like the instant the matter we are discussing, I think 24th and 26th or thereabout. And then you expect that the judge in Kebbi would have known, except in this instance it's different because there was reference, which I agree with Ubani. That's why this one is very disturbing and very clear, it's apparent on the face of it, that it falls within the purview of giving conflicting decisions. But looking at it critically and moving forward, I think that we have to expand our frontiers of deploying technology in the judiciary in this country, and we've been advocating for this in many instances. It's not just about the courtroom, the technology, where we would have eased the burden on the judges. We have counted on this. And then right now we're talking about even how judges should be anywhere and knowing what is happening within the judiciary seamlessly and almost like instantly. Then you can't do that except you deploy technology. And that's also one of the issues we have also advocated, the true and truly effective independence of the judiciary financially in that regard, so that the judiciary should be able to identify and know what challenges they have and then deploy their resources and their finances in that direction. So if they fail to do so, we hold them responsible. But a situation where you have the judiciary not being truly and effectively independent financially, then you find a situation where those who would want to come and infiltrate the judiciary, we deprive them of certain facilities that will probably make their job more effective. So in all of this, I think that it's a disturbing situation where we will have the judiciary be drawn into this embarrassment, both by the bar and the bench, because we're all stakeholders in the judicial process in this country. It is not just, Ubani also alluded to that sometimes it could also be how the courts present matters before the judge, that the courts, the bar will have a responsibility to disclose information to the courts, to the judges, and that's true. So where you are filing a process and you are quite aware, how are we going to discipline these lawyers? And that's why the NBA is also involved, because the disciplinary committee of the NBA is the one that is vested with the responsibility to discipline erring members of the bar. So you are quite aware, very well, so much aware that this matter has been considered or is before a judge of the same subject matter. The subject matter is the same, and you're filing, you can't advise your clients. Even sometimes, that's the thing that we need to also really be up on the beat. If clients come before you, some of us who are even not as much senior as some of those fortunate seniors that would take these matters, are very conscious of that. And we are bold enough to tell our clients that, look, this matter this way, advise your clients very candidly. It's also a responsibility of a diligent member of the bar. So in all, I think we are making some progress in purging judiciary and then our entire system of the inadequacies that exist and have actually impinging our integrity and the confidence of Nigerians in the judiciary, which we always would say is the common hope, is the last hope of the common man. It should be so.
Barrister Erikile, thank you for that opening, pretty long opening remark. Let's move on to Anthony Oseme, who is joining us from Delta State. Barrister Anthony, now it seems like the CJN has come to the rescue of all of these anomalies that's been experienced within the judicial sector of Nigeria. Very key for me is I'm aware that the three judges are meant to face the NJC panel sometime next week. I'm also thinking just maybe the penalties should go beyond the three judges, and even the lawyers that did file in those cases should be reprimanded and also maybe cautioned. What do you think?
Yeah, actually, thank you for having me. Good morning. The judiciary is on trial presently, going by the conflicting orders we are having from courts of concurrent jurisdiction in Nigeria, considering also what we have at heart now. The judiciary is on trial, and that trial is trying to rebut the fact that judiciary is the last hope of the common man. The last hope of the common man, where the common man looks up to and tries to seek redress. But you find out that the foundation of the judiciary is being rotten. People are trying to use every arsenal within their disposal to make sure that the judiciary is not dependent. And that is why you see these type of orders coming left, right, and center, conflicting orders for that matter. Now, the NJC has actually come to the rescue, where the chief judge who actually invited these judges in order to let them know the oath they're taking, the oath of respecting and applying the laws of the land and respecting the Constitution. And also the NJC has also taken bolder step, because it is the NJC that has the powers to reprimand, to caution, to suspend, to dismiss, or do anything against a hearing judicial officer. So the NJC has done its best, and we hope that after these next week meetings with these judges, that they will have more respect for the judiciary, and the hope of the common man will be restored in the judiciary. Having said that, you asked me about the lawyer. The NJC is not a body that is saddled with the responsibility of punishing or cautioning or awarding penalties against a legal practitioner. Rather, the Legal Practitioner Disciplinary Committee is a body that is saddled with such responsibilities. And I think the current NBA leadership under the distinguished and dynamic Mr. Olumide Akpata as the president has frowned on lawyers who, in one way or the other, trying to get ex parte applications, entering orders that smacks of mockery in the eyes of any little person in the country. So the NJC, the MBA has taken steps towards that. I'm also aware that there's a town hall meeting, there's a meeting of lawyers where we want to discuss issues bordering abuse of ex parte application, and so that we know our stand as lawyers. So the MBA is taking a stand, and we support the MBA on that stand. Lawyers should know that our primary duty is to the court. The court, we are ministers in the temple of justice, and as such, we must at every point in time hate the judge, hate the court, even if it is against our client's interest, hate the judge to make sure that we get justice. Justice is what we are fighting for, and we cannot sacrifice justice at the temple, at the altar of financial greed, at the altar of blood relationships, at the altar of party affiliation. No. Justice must be served, and justice must be served, and lawyers must aid the court. Lawyers must aid the court to so do. And again, looking at what we're having now in this country, it tells us again that we need to have, like my earlier speaker just said, that we need to employ technology in what we are doing in this country. Because if the judiciary actually has a template to embrace technology, it will help us to keep track with every judgment and every ruling and every order that we have in different courts, especially when it comes to courts of concurrent jurisdiction. So you know how to do it, so you don't make a mockery of the judiciary system. Again, right. we must say that the reason why most of us were crying for the autonomy, the financial autonomy of the judiciary has not come to bear, because where you expect the chief judge, the chief judge of the federation going cap in hand, asking the executive to give them money to do what they need to do. You are simply saying that the judiciary is not independent.
I mean, Anthony.
So when we have this financial autonomy, it will aid us to make sure that we use our money to deploy technology, to have good and current best practice, and ensure that justice is delivered. So
all right,
I think
Anthony.
the NBA is doing very well, and the NBA will look into it and say that those area lawyers are accountable. Thank you.
I mean, what you just mentioned now paints the picture well of the adage that says, "He who plays the piper dictates the tune." And that is why judicial autonomy is very important at this particular stage. But let's still stay with disciplinary measures, as all the lawyers we've spoken to today have mentioned. I mean, it's very important that gets done so we can nip this ugly trend in the bud. Let's head back to Port Harcourt with Henry. The CJN summoned and, of course, have said 3 of the judges will be punished. I'd like to get a reaction to the part where some of your colleagues are even arguing that, you know, it should be left with the NJC to actually put disciplinary measures in place. So where do you stand on this?
It's discipline that actually ensures or guarantees integrity, really, in any system. So I think that the efforts of the National Judicial Council established under Section 153 of the Constitution of the Federal Republic of Nigeria 1999, and then having its functions and powers under the third schedule to the Constitution. Is very extant and very, very imperative, very important and very crucial to continue to instill discipline in that section of judicial system, that is the bench, the judges at all levels. And then the Nigerian Bar Association also having its own institution for discipline, and that is the disciplinary committee of the Nigerian Bar Association, and very active. A lot of judges on the side of the NJC have received one form of discipline or the other. As members of the bar, the disciplinary committee of the NBA has been very active, and then there has been reprimand and all kinds of punishments or sanction against erring lawyers at all times. And if these institutions are effective and effectual, and of course discipline is instilled within the stakeholders in the system, then we would expect that perhaps there could be deterrence for those who have conscience. I would say so because sometimes you really would have the legal framework, you could have the institutions in any system, and then when stakeholders are just determined with impunity to deter from those extant regulations and restrictions, you will still have a disturbing situation as we're having now. Otherwise, there is no one who does not know the circumstances that are ideal and very reasonable to applying the discretionary order of a court to make an interim order pursuant to ex parte application. We agree that Section 6 of the Constitution that creates the courts and then vesting the powers in the courts to entertain and determine all matters that come before them, provided they are within their jurisdiction, probably stretches the boundary, of course, even the inherent jurisdiction. But it is further required that in doing so, you should be seen to be judicial and judicious. And that's where we have these issues here now. The infiltration by persons who, for them, they will not receive this blame when we have this very decayed situation and very disturbing situation. So discipline cannot be undermined and cannot be overstated in any circumstance, in any system, including the judicial system. And that is why we must emphasize on discipline, on erring members of the bar, and of course the bench as well, with very much respect to members of the bench. I think it should even begin with them. I say so because I think that but before you are appointed a judge or brought to the bar, into the bench, you are required to have exhibited and shown enormous experience, and then you sit there also as a compass and as a guide even to members of the bar. And that's why even in the fiscal court, when you're there, sometimes you get to admonish lawyers where they are erring. You have that responsibility as well. So it's also worrisome if much of these problems come and then the bench is not seen to be admonishing, even before it gets to the level of the NJC, admonishing lawyers. Sometimes they do. Why are you bringing this kind of application before me? Or again, coming clearly on ex parte applications. The courts, most times, I have had that experience. I believe that most of my colleagues as lawyers have also had that experience. You could file an ex parte application, and then the courts will generally ask you, no. The nature of your prayers, the way you have couched them, I won't grant this order. Put them on notice very quickly. And you know that the power to abridge even the time that the respondent is even expected to answer by an order of court. You can actually look at the urgency of the matter, because your order on that ex parte application could go a long way with a very serious implication. And in this case, even that is political, could almost determine what you would even probably consider in the substantive motion or notice. So why not you rather, they taught us this, they guide sometimes in this direction, put this other party on notice very quickly. And of course, even make an order to abridge the time that if you are required perhaps to respond in 14 days, the court has the power inherent to tell the respondent that respond, provided proof of service is shown, respond in a short time, bring every party together and quickly, expeditiously look into the matters that are very crucial and make one decision one way or the other that can cover the field. But where you have a situation where you look at the prayers in the substantive motion or notice,
yes,
and then you look at the prayers in the ex parte application, and you know that if you decide one way or the other, the ex parte application is going to seriously affect the outcome and even predict the outcome in the motion or notice. In practice, these are the issues.
Eric, yes, I like the part where you were suggesting a top to bottom approach in dealing with the punitive measures to be taken within the sector, top to bottom approach. But I don't know if the NJC have the right to penalize the bar, in as much as I know they have the right to the bench. I'm sure Anthony did talk about the fact that there's a legal body that could deal with the bar. But then let's go, Anthony. Let me come to you briefly because we're running out of time on this conversation. Yes, the CJN has come to the rescue. We hear that 3 of those judges will be facing the NJC panel sometime next week. Without trying to preempt what the punitive measures will be, I don't know, correct me. I'm waiting to know if we've ever had, if at any time in the history of the sector, of the judiciary sector, we've had judges penalized. And what kind of measures were they meted with in their penalty? So, in essence, I'm trying to say, what do you think could be the penalties that could be meted on these judges if found wanting in these allegations?
Yes, okay, is it me, really?
Anthony.
Okay, the not scheduled to the Constitution of the Federal Republic of Nigeria actually deals with the provisions for punishment and discipline of erring members of the bench, that is judges. It is true, as my colleague also had said, for the NJC is the bench. And then just clearly, like almost all disciplinary procedure, even in the private sector, when there is an allegation or suspicion of infraction by any member of the bench, then of course he will have a query being invited and a panel of the NJC being set, which is what we're seeing here. And then of course the fair hearing will be given if that's the procedure. Then you get to the end. If it's found wanting, then it could be a reprimand, and judges have been reprimanded, because you were asking whether in history if this has happened. It could be a suspension. Judges have been suspended over time, a number of them. It could even be a recommendation for dismissal, and what the NJC would do is a recommendation for these disciplinary measures. It could be a recommendation for dismissal to, if it's a state judge, then of course to the governor of the state, that this judicial officer should be removed, should be dismissed. If it is a judge of a federal court, then a recommendation to the president for the dismissal of that judge. So clearly, and without mentioning the words, the disciplinary measures that could come against an erring member of the bench could range from reprimand to suspension to dismissal. The same way, but on the other hand, the disciplinary committee of the Nigerian Bar Association, if a member of the bar is found wanting, it could also range from probably suspension, of course, reprimand as well as suspension, and you may be, in some instances, let's take one. Assuming you are a member of, or you are a senior advocate of Nigeria, you could be derobed. You could be that rank could be taken away from you. That's discipline. And then in some of the cases, you actually could be suspended for a period, or outrightly be debarred. That is where your name will be struck out of the role of legal practitioners in this country, that is kept by the registrar of the chief registrar of the Supreme Court. That is, you are no longer eligible to practice as a legal practitioner in this country. My colleague Sirius, sorry about that, continue at some point.
Thank you so much for that wonderful comment, Henry Akini. Actually, the question was actually targeted at Anthony, but it's okay as you have made a comment on it. Anthony is going to give his comment on it in a bit, but this is where we'll say thank you so much for joining us on today's edition of News Hub. It's been a powerful contribution that you have made to this particular topic, and we do hope that we see good out of it, and disciplinary measures are taking place, sustained and maintained, so that such embarrassments will not happen again to the prestigious profession as it is, that legal one as it is. Thank you so much, Henry, for joining us.
Thank you very much for having me. My apologies again to my colleague.
That's fine, that's okay. All right, so let me focus on Anthony right now as we say goodbye on this particular segment. still talking about the body or bodies that are interested and involved in this case. Let's take a look at the NBA. There have been fingers that have been pointing at the NBA that they should take responsibility for some of the rots that we see or be experiencing into this judicial, in the sector that we're talking about here today. What are your thoughts on that?
Well, I think the NBA is not a problem, but certain members of the profession may be the problem. And actually, Chief Wandubani has actually said that sometimes these clients don't disclose the real facts as it were before the lawyer takes the matter to court. And having said that, we still have to know whether it is the lawyer who deliberately decides to take a matter that is as frivolous, a matter that is ridden and filled with concealed facts before a court, or is it a client who on his own try to truncate the course of justice? So basically, and that is why the NBA has been calling for a discussion. We want to talk. We want to talk to ourselves. We want to hear ourselves out. We want to place our actions vis-a-vis the law. We want to see if our actions, our duties towards the court, our duties in ensuring that justice is done to all man, irrespective of color, creed, or whatever, justice is done to every one of us. If we are doing that, then why, and those who are not towing that line, what do we do to such people? That discourse is going on currently under the NBA and under the administration of Olympic Abata. And I think it is the right way to go. Now, take it. Some lawyers may be bad, some may be doing this, but that is why we are trying to stem the tide. We want to make sure that such practice is not found within lawyers in Nigeria. Now, having said this, before, as my closing remark, now, we must look at our appointment processes of judicial officers. How do we appoint judicial officers? We must make sure that competence should be the watchword and not federal character. If we are appointing judges to the Federal High Court, we shouldn't use federal character. We should use competence. Lawyers in practice, we know lawyers in practice. We know what we do in practice. So it is lawyers with competence. Judicial officers should be people with competence. You appoint people with required legal competence to do the job, and not just that, character. Character of every judicial officer matters a great deal. Now, if we have experts of the law without character, you're going to get sacked. So we need, in our appointment processes, we should look at the character of judicial officers. We should look at the legal competence and expertise of those judicial officers. It is very, very important, because these are people that will saddle and sit and administer justice to all people. Now, when a judicial officer is not abreast with the current trend of the law, you find it's a disaster to everybody. So I think we should look at that line, and while at NBA we continue discussing and talking to our members to ensure and respect the court, the institution of justice, and make sure that we carry on our duties as lawyers to the court at every point in time, irrespective
Anthony,
of its court.
Anthony Oseme, that's a twist to the conversation, but then I think it is extremely very vital. Thank you for your time with us on the show, Anthony. We appreciate your inputs and your thoughts. Thank you so very much, a legal practitioner. Thank you.
Thank you. Thank you for having me.
And Barrister Henry Kine, always a pleasure having you talk to us on the show. Thank you for your thoughts as well, and do have a great day as well. Okay, so that is where we call it a wrap on this segment. Mercy, we'll take a break. We'll come back. There's so much has been said on this segment.
Yes.
Interestingly, I'm excited that at the fact that the eyes of virtually everyone is on the judiciary.
Absolutely.
And they must begin to live up to the billing. They must begin to live up to the expectations of the common man. they must be looking to live up to the expectation of everyone in Nigeria. Interesting conversation. We'll take this quick break. When we'll come back, we'll be looking at a very important conversation again. We did intimate you earlier, looking at the place of the Nigerian youth in determining their future and the future of this country. Don't go away. It's still NewsHub.